Hello, everyone. I'm going to call this meeting to order at 6 p.m. and I'll hand it over to the Deputy Mayor for item 2.
Okay. The Council of Corporation of the Township of Hornepayne would like to begin by respectfully acknowledging that the land on which we gather here today is the Treaty 9, 1905 to 1906 territory, the traditional lands of the Indigenous peoples. As we work towards reconciliation, may we all live with respect on the land and live in peace and friendship with all its diverse peoples.
Thank you. Okay, we do have one addition to the agenda. It's item 7.2, Treasurer's Statement of 2025 Council Remuneration and Expenses. So if I can get a mover and a seconder to moved by Councillor Peter Kismer, seconded by Councillor John Carroll. Be it resolved, the council does hereby approve the agenda as presented. Those in favor? And that is carried. Declaration of pecuniary interest, declaration of conflict of interest. Council, I don't have any paperwork on that at this time. You can do that at any time throughout the meeting if such a situation arises. And we have a presentation tonight. I'm glad to welcome you to Hornepayne, John, and
Thank you, Worship.
there we go. Okay, we're just getting started. Yeah, we'll just take a minute. Sorry about that.
Okay, so thank you for having me here tonight, Mayor Council. My name is Sean Sparlin, and I'm with expertise municipalities, your integrity commissioners. You'll see the reports under my own entity, it's SPS Inc., and they frequently contract me to do their investigations. So what I have here tonight is a report, public report on quite a number of matters. I'll apologize up front. It's a lengthy report. Happy to take a break if anybody just interrupt me if we need to take a break. And I'm only estimating, I think it's going to take me close to an hour to read it. Okay. I'm not going to read certain portions of it. It's not because it's not in the report. It is. It's just that it's the legalese and it's different sections of the code and stuff like that. But it's in the report if somebody wants to look at it. I'm just going to skip over those, just trying to save a little bit of time. The report itself is a public report, and it has been posted to the municipality's website at this point. Am I correct on that?
Yes.
Sarah, now?
Well, to the agenda.
Yeah, okay. So it's a public, it's a released report as well. That's really all I have to start off with. Does anybody have any questions before I start at all, or? No? Okay. And at the end of it, happy to answer any questions that your worship or council might have.
Okay, thank you.
Okay, I'm gonna get right into it. Okay. Expertise from municipalities and appointed integrity commissioner for the Township of Hornepayne. As the integrity commissioner, E4M is a statutory officer of the municipality. The integrity commissioner reports to council and is responsible for independently performing functions assigned to them by the municipality. The Municipal Act awards the integrity commissioner a number of powers that the integrity commissioner can exercise while conducting code of conduct and municipal conflict of interest act inquiries. The municipality and its local board shall give the integrity commissioner such information as the commissioner believes is necessary for an inquiry. The integrity commissioner is also entitled to have free access to all books, accounts, financial records, electronic data, and so on, as the integrity commissioner believes necessary for the inquiry. E4M has appointed Sean Sparling, which is me, from SPS Inc. to investigate and report to council on this matter as an agent for E4M. Overview of the complaint. This public report pertains to several complaints filed by the same individuals against Mayor Cheryl Ford. There are complaints filed under the Occupational Health and Safety Act, Municipal Conflicts of Interest Act, the Ontario Human Rights Code, Code of Conduct related to elected officials for the municipality, and so on. There's a long list of complaints addressed in this report. This is the very first complaint goes back to May 2024, and the last complaint was filed February 27th of 2026. The complaint on February 27, 2026 was made against council as a whole, including Mayor Ford. There are important contextual facts surrounding the complaint that are not evident within the complaints themselves that are relevant to these matters. It is also important to understand that there are two primary complainants against Mayor Ford. These complaints are closely related to each other and have a very clear personal interest in the outcome of this inquiry. For the purposes of the report, the complainants have been identified as C1 and C2. C2 has been involved in various complaints with Mayor Fort since 2020. That began outside of her role as mayor for the municipality and involved her personal employment. As part of our inquiry, we have completed a detailed credibility assessment of the complainants and the respondents. These are found in Appendix A of this report. In summary, C1 and C2 were found to be not credible or reliable in their evidence. The respondent, Mayor Fort, was found to be credible and reliable in her evidence to the inquiry. Historical context, C2. The following historical information is contained in a publicly available adjudicator's decision dated January 22nd, 2024. In April 22, Mayor Fort and C2 were co-workers. Over the course of April 24 to 26, 2020, C2 engaged in conduct directed at Mayor Fort, which is later found to be a violation of the workplace harassment policies. During these events, C2 repeatedly communicated with Mayor Fort by electronic messaging. The following is a short summary of what C2 communicated to Mayor Fort. Quote, false pretense, it's all bullshit, you're only fooling yourself, and all those who do not know your true self, what a joke, you're such a fraud, think again, you selfish bitch, you are sick in the head. The adjudicator found that C2 comments to Mayor Fort were, in quote, reasonably be expected to cause offense, humiliation, or physical injury to his co-worker, Mayor Fort. Specifically, C2 was found to have threatened Mayor Fort with physical violence. The adjudicator also commented the words fairly well, followed immediately by the knife, and reasonably understood as a threat of physical violence. C2 was dismissed from his employment due to the findings of misconduct directed at Mayor Fort in their workplace. In upholding the dismissal, the adjudicator stated, misconduct in this case is very serious. His messages were offensive and humiliating, and it could reasonably be interpreted as a threat of violence. C2 has not accepted responsibility or truly apologized for his behavior. Oh, 1 second, please. Pages went into order. This inquiry is not meant to relitigate the historical matters involving C2 and the Mayor Fort. They are part of the natural history of the complaints being reported here and provide an important backdrop to all the complaints filed against Mayor Fort by C1 and C2. Historical context, C1. In 2020, Mayor Fort filed a workplace complaint involving C1 under the municipality's workplace harassment policy. An external investigator concluded that C1 had breached the policy. The municipality implemented measures, including restrictions on direct one-on-one communication between the mayor and C1, along with other internal administrative actions not described here due to the confidential nature of the employment matters. These restrictions remain in place during the period relevant to this inquiry and provide context to the subsequent complaints by C1 and C2 in helping to explain their interactions between the parties. Code of conduct allegations against Mayor Fort in 2024. In May 2024, C1 submitted a complaint against Mayor Fort to the Integrity Commissioner under the Code of Conduct, citing 15 alleged contraventions of the code, as well as potential breaches of provincial legislation. This included including the OHSA and the OHRC. The allegations dated back to 2018 and related to interactions between C1 and Mayor Fort. A comprehensive investigation of the allegations was conducted and a detailed report was prepared in accordance with the municipality's workplace policy. The report cannot be released publicly due to the confidentiality protections that apply to this type of investigation. With respect to the allegations of breaches of the Code of Conduct, it was determined that Mayor Fort had, on occasion, exceeded the proper boundaries for her role in interacting with staff. The Integrity Commissioner at the time provided guidance regarding the appropriate role conduct, and the mayor cooperated fully with the recommendations and adjusted her practices accordingly. Any further elaboration on the specific actions or circumstances cannot be provided, as doing so would be contrary to the confidentiality protections that apply to that investigation. Under sections of the Municipal Act, the Integrity Commissioner may report to Council publicly on any matter the Commissioner considers appropriate. While the Integrity Commissioner does not regularly mention workplace harassment complaints in public reports, it is necessary for the context and analysis herein to include mention of these matters. The summary provided here constitutes that report in accordance with the Act. As these matters were fully addressed during the Integrity Commissioner inquiry, and the Commissioner is satisfied the issue has been remedied, they do not form part of the present inquiry and will not be considered further in this report, except insofar as they referred as to providing historical context. Conflict of interest allegations, Mayor Ford. Prior to July 2025, C1 was employed by the municipality. On July 30, 2025, C1's employment was ended as part of a restructuring of staff positions. On August 29, 2025, C1 swore an affidavit in support of allegations that Mayor Ford breached the MCIA under sections 5, 6, and 7 and the municipality's Code of Conduct Bylaw 1749 for improper use of influence, breach of confidentiality, and interference with staff. There were many other ancillary complaints filed by C1 under the guise of the MCI complaint and the Code of Conduct complaint against Mayor Ford. The allegations by C1 were, to say the least, voluminous. The effort to distill the complaint into something manageable was considerable. In completing this investigation, the inquiry interviewed C1, the CEO for the municipality, Ms. Manuela Badavania. The inquiry also reviewed very extensive documentary evidence that included meeting minutes from open and closed sessions, the staff restructuring plan created by Ms. Badavania, as well as several other related items. Based on the two interviews and the material reviewed, the inquiry was closed. Details of the conflict of interest allegation. C1 provided that she had been an employee of the municipality since 2015 and that Mayor Ford was first elected to council in September 2016 and became mayor in 2018. C1 explained that she was off work from October 2023 and returned to work in February 2024. When returning, she was disciplined for a matter. As a result of this, she filed her OHSA complaint against Mayor Ford and another municipal employee. This was filed on May 2nd, 2024. C1 went off work again and returned in July of 2025, just prior to the restructuring of the municipality. In summary, C1's complaint is that Mayor Ford participated in several closed session meetings of council to discuss the restructuring of the municipality while being the subject of the OHSA complaint that C1 filed against Mayor Ford. C1 believed that Mayor Ford used the restructuring as a veiled means to terminate C1's employment with the municipality, and in doing so was creating a conflict of interest for herself. Under the MCIA legislation, a conflict of interest has to amount to some type of pecuniary interest for Mayor Ford. The language in the MCIA is very specific on this point. The language found in Bylaw 1749 mirrors the MCIA regarding pecuniary interest. However, it does expand the definition considerably. It is much broader in the application than the MCIA. There's a more fulsome definition of the MCIA in Bylaw 1749 in the analysis section of the report. C1 was asked to explain exactly what the pecuniary interest Mayor Ford had in the restructuring of the municipality. C1 felt that through the restructuring, Mayor Ford was limiting her and the municipality's liability regarding the harassment complaint. C1 also believed that through the restructuring, Mayor Ford was lowering the level of scrutiny on her own personal expenditures submitted to the municipality. C1 stated. So question to C1, is there anything that occurred that financially benefited her by doing any of this? Let's say she manufactured your termination. How does that benefit her financially? Answer, not in that moment. For preventing me from going forth with any further action against the township and the mayor. C1 asserted in her affidavit that Mayor Ford breached the MCIA by influencing matters despite conflicts, controlling public narrative, and benefiting from confidential information. C1 was asked directly if she had any evidence to support any of these allegations, and her response was, quote, nope. With regards to reducing the oversight of the mayor's expenses, C1 indicated, quote, if If she gets me out of the way, I follow the rules. She can get me out of the way, then she can manipulate and twist the rules to get what she wants." End of quote. C1 has asked repeatedly if she had any actual evidence to support the extensive allegations she made against Mayor Ford. By far, the majority of the complaint was based totally on C1's own assumptions and conjectures. She also based some of her allegations on rumors that she attributed to the community or staff members at the municipality. There are also several allegations made by C1 that were not part of the MCIA complaint or even against Mayor Ford. Each of these allegations was put to C1 and she responded that they did not apply to the complaint about Mayor Ford, but included them for reasons only known to her. For example, February 12, 2025, the township fabricated the title of office manager and promoted her into the position of clerk without a proper bylaw authority. C1 was asked why this mattered in the context of the MCIA complaints against Mayor Ford, and she answered, "It doesn't matter to the MCIA complaint." C1's complaint is replete with similar accusations and statements that are irrelevant to the MCIA or code of conduct complaint against Mayor Ford. In another example, C1 alleged that staff members, including Mayor Ford, were breaching confidentiality. The context was one employee telling C1, while presumably breaching confidentiality, that another employee told her about Mayor Ford's actions in filling the various vacancies at the municipality. C1 was asked how this was relevant to the complaint she filed against Mayor Ford and how she even knew that Mayor Ford was involved in these staffing decisions. C1 responded, "Because I'm of the opinion that she's getting all this information in regards to the harassment complaint and then orchestrating changing senior management roles because she has knowledge of confidential information that she shouldn't have and is in a position to orchestrate these things and then eventually gets me out." To support the above statement, C1 produced a text message between herself and another staff member. The staff member attributed her knowledge to a second staff member. Mayor Ford was not at all referenced in the text message. C1 was asked directly how she knew Mayor Ford was involved in this issue at all, and C1 replied, "No, I don't know." C1 did not provide any evidence to support the allegations against Mayor Ford. At best, her allegations were conjecture and assumptions on her part. She also failed in any way to connect the alleged actions by Mayor Ford to a pecuniary interest under the MCIA. In reading the written complaint filed by C1, there was a portion that appeared to have been authored by another party. The language is different from the rest of the complaint. It was a different tense and so on. This was raised with C1 and she was asked if she had any assistance preparing the complaint and she answered that she did not. After information from Mayor Ford. After interviewing C1, the investigator met with Mayor Ford to advise her of the complaint. Mayor Ford was visibly upset and shaken by the allegations. It was not the allegations themselves that upset Mayor Ford, it was the constant ongoing complaints directed at her from the complainants, C1 and C2, that are quite visibly taking a personal toll on her. Mayor Ford explained that she had nothing to do with the restructuring in the municipality and had recused herself repeatedly from the matters having to do with C1 during the course of the OHSA investigation. She also explained the actual restructuring plan undertaken by the municipality was the CAO's idea and that she implemented it in her role as a senior administrative employee. Interview of the CAO, Manuela Valvania. The inquirer interviewed the CAO for the municipality. She explained that prior to being hired by the municipality in her current position, C1 was off on leave from the workplace. This leave continued throughout her own Valvania's hiring process. During her pre-employment interview, she presented a restructuring plan as part of a competition. In that plan, she outlined the steps that she would take if hired to reduce costs and increase efficiencies in the municipality. This included bringing asset management in-house, restructuring the various administrative functions, identifying opportunities she saw in public works, and not renewing a contract position in the economic development office. Ms. Badavania further explained that once she was in the position as CEO for the municipality, she had to manage all the municipality's operations, and that included implementing the proposed restructuring she laid out in her interview for her new position. Mayor Ford was not part of this planning process for the restructuring. In fact, current council as a whole was not involved, except for being made aware of the restructuring plan and providing their direction to proceed. The inquiry is unable to provide further details on the direction from council as it forms part of solicitor-client privilege. The restructuring of C1's position was the first step of many in this process. Ms. Badavania explained that anytime there was a direct conversation about C1, Mayor Ford declared a conflict and recused herself from the meeting. Meeting minutes and restructuring plan. As part of the inquiry, the various meeting minutes, including closed session, the planning documents for the restructuring, and the presentation Ms. Badavania gave during her hiring have been reviewed. This inquiry also reviewed all Mayor Fort's declarations of pecuniary interest from the time C1 filed her OHSA complaint against Mayor Fort, the time the restructuring was implemented that resulted in C1's job loss. The final restructuring plan was presented to council on July 23, 2025. This was after the OHSA investigation involving C1 was completed and found to be unsubstantiated. The restructuring plan includes the following: a detailed staff comparator between 10 communities of similar size, including Hornepayne. It demonstrated that Hornepayne had a higher number of administrative staff than all other comparator communities. The plan included 10 recommendations on how to reduce staff and the means to gain efficiencies. The evidence gathered regarding the restructuring clearly demonstrated the following: the concept of the municipality, the restructuring of the municipality clearly originated from Ms. Badavania, as this was prior to her hire. This was the first presented to the hiring committee well before C1's return to work. The final restructuring plan was presented to council on July 23, 2025. This was after C1's allegations under the OHSA were released and she had returned to work. Mayor Fort recused herself from several discussions involving C1, mostly surrounding the OHSA complaint and legal matters involved in C1. Mayor Fort filed several declarations of pecuniary interest leading up to the final restructuring plan being presented by council to Ms. Badavania on July 23, 2025. Mayor Fort was not involved in creating the final restructuring plan, nor was council as a whole. It was an operational matter left to Ms. Badavania. C1 was not the only job loss in the municipality. When her position was eliminated, the decision to end the economic development contract was also made. At this point in the inquiry, the matter was concluded. There was no basis to continue the matter as it was clearly a frivolous complaint. September 17, 2025, Town Hall meeting. On September 17, 2025, Council for the municipality hosted a Town Hall meeting. This has been a semi-common practice by the council whereby they allow members of the public to ask questions of elected officials. This was a meeting of council, and as such, rules of decorum, civility, and so on apply. During this meeting, C2 was asked to leave the meeting by Mayor Fort due to his behavior. C2 was escorted from the meeting by the police. C2 filed a code of conduct complaint against Mayor Fort for removing him from the meeting. C2 complaint was filed by email on October 25, 2025. He had attempted to file the complaint with the municipality prior. However, Ms. Badavania had refused to commission his affidavit for the complaint. This issue will be addressed later in the report. The Town Hall meeting was recorded by a member of the public and made available to the inquiry for review. This allowed for an unbiased review of what occurred. In his complaint, C2 alleged that when Mayor Fort had him removed from the Town Hall meeting, she abused her authority and power. She made misrepresentations to the OPP by claiming he was in violation of the Township's Procedural Bylaw 2047, but only provided the section 4.3.1, omitting the remaining sections that have the required process for addressing an attendee. This omission caused the OPP to act without lawful basis or justification. That she breached municipal bylaws, trust, and violated C2's charter protected rights as a citizen lawfully attending a public meeting. That Mayor Ford addressed C2 in a confrontational, accusatory manner. That without any warning, motion, or vote of council, Mayor Fort directed that he be removed from the meeting. C2 also alleged that Mayor Fort committed the following criminal offenses: public mischief, obstruction of justice, and breach of public trust. C2 also quoted a variety of case law in support of his complaint. The following is a quotation from C2's written complaint about Mayor Fort regarding the Town Hall meeting. Quote, Mayor Fort's deliberate withholding of the full bylaw coupled with her direction to police based on incomplete information, fall squarely within the principles articulated in these cases. Her actions were inconsistent with her statutory duties, carried out in bad faith, and represented a misuse of her official authority for improper purpose. In distilling C2's complaint to its core, it's about him being ejected from the September 17th, 2025 meeting by Mayor Fort and her not following the procedural bylaw to do so. There are ancillary complaints that she provided false or misleading information to the police, which are acted upon to remove C2 from the meeting. The issue of Ms. Badavani refusing to commission C2's complaint is not a matter that is within the jurisdiction of the Integrity Commission. It is a matter to be addressed by council for the municipality should they choose to do so. I have addressed it in this report solely as it is relevant to the overall narrative of this complaint, C2's credibility, and these matters in general. Interview of C2 in regards to the town hall meeting. To fully understand C2's complaint, he was interviewed as part of this inquiry. The following are the relevant excerpts from his interview. He attended the meeting on September 17th, 2025, and everyone was allowed to ask questions. He asked about the tax rate in Hornepayne, which is 5.47%, but no one on council knew the tax rate, which made them, council, uncomfortable. He was attempting to question the CEO, but Mayor Fort said he was trying to make them look bad. She said he wasn't going to make them look stupid, and he got kicked out of the meeting. Council didn't follow the procedure to kick him out of the meeting. There's supposed to be a discussion, then a vote to do this. C2 was asked if there was a reason why he was removed from the meeting. For example, was he behaving? C2 advised that he was quiet. C2 was asked the same question several times. He stated that he was not arguing or being confrontational at all. C2 complained that they only put one piece of the bylaw on the screen about the attendee's conduct. By not putting the whole bylaw up, Mayor Fort misled the OPP in the process of having him removed from the meeting. C2 felt like Mayor Fort acted like his charter of rights did not exist. C2 was asked directly, were you being argumentative or raising your voice? You weren't warned or anything like that. C2's response was, Mayor Fort said, you're trying to make us look stupid, get out. Mayor Fort told the police to throw him out. They got up and threw him out. He said he had charter rights under Section 2, and the thing he said that they deemed was offensive was that they didn't know the tax rate. Mayor Fort never warned him before she kicked him out of the meeting. C2 was adamant that he was polite and there was no reason for Mayor Fort to have him removed from the meeting. C2 was also asked to explain the issue he was raising about the commissioning of his affidavit for this complaint. He advised that when he attended the municipal office to file the complaint, he presented to Ms. Badavania to have it commissioned as required by the complaint process. She refused, directing him to take it to another Commissioner of Wolves. C2 submitted to the inquiry that Ms. Badavania is required under the Notarization Act to commission documents when asked to do so. The Ontario Notaries Act governs commissioners of oaths in Ontario. The legislation has been reviewed by the inquiry, and there is no requirement for a notary to provide such a service as described by C2. The Notaries Act says the notary may provide the service, not shall. C2 is incorrect in this submission to the inquiry. This issue was canvassed with Ms. Badavania. She explained that there's no requirement for her to commission this complaint. She was concerned about C2's ongoing behavior and did not wish to facilitate its continuation. She advised C2 to attend another notary to swear the document. Ms. Badavania explained that C2 continually contacts the municipality about his complaints. Since August of 2025, C2 has sent 48 emails on a variety of topics. He has copied numerous officials from the municipality in different levels of government. In these emails, he is very demanding and makes repeated accusations against staff in the municipality. This is in addition to his personal attendance at the municipal office for various access to information requests that he has made. Throughout his interview, C2 also lamented that council members in general do not respond to his emails or questions about other matters that he raises with them. The inquiry also raised with C2 the perception that he is making these complaints as the restructuring directly impacts C1 losing her position with the municipality, which for him is a conflict of interest due to their close personal relationship. It was also raised with C2 the historical harassment issues involving Mayor Fort. C2's response was that regardless of these other matters, he cannot be deprived of the law. It was put directly to C2 question. I've been told that you were rude that you're being obstructive of the meeting, and that you were warned a number of times to stop, and that finally you were kicked out. I'm told you're doing this basically to continue to harass the mayor, and it has to do with C1 losing her job at the municipality. C2 did not directly answer this question. Instead, he suggested inquiry should cross-examine each of the councillors to see if he was rude. He also spoke of his unrelated complaints against the municipality, that he wanted to submit supplemental materials to the inquiry, and then he lamented the previous findings of harassment against him involving Mayor Ford. During the interview with C2, C1 could be heard in the background. C2 called to C1 by name and had C1's research case law and then send it to the inquiry. Recording of the town hall meeting from September 17th, 2025. The full town hall meeting for September 17th, 2025 was recorded. The inquiry has reviewed this meeting in its entirety. At the beginning of the meeting, the mayor announced that they had the OPP in attendance as special guest. She explained that the idea to have the OPP at the town hall meeting was for the community to meet the officers. This came about based on engagement with the OPP to increase their presence in the community. Therefore, to introduce the officers to the community members in attendance. Mayor Ford also put the expectations for everyone regarding their conduct on the screen. She explained that this event was a meeting of council and there would be debate as long as it was respectful. Mayor Ford also advised the audience that she would hold everyone to the standard, including council and members of the public. She further explained that if anyone behaved disrespectfully, she would issue one warning, and depending on the severity, she would ask the individual to leave. If needed, she would also ask the police to escort the individual from the meeting. On the screen behind Mayor Ford was one slide with information relating to the procedural bylaw on this issue. She did not read from it, but had it on the screen, presumably for information purposes. One of the rules for those asking oral questions of council was that they had 2 minutes to do so. At 39 minutes and 20 seconds into the meeting, C1 asked questions of council. Her question was in writing and read out and answered by staff. It related to the closed session of council from July 25, 2025. The second question related to financial reporting for the municipality. It cannot be readily answered as staff did not feel there was adequate details in the question. C1 was invited to submit more details, and a response will be provided to her. At 45 minutes, a question came from a member of the public not involved in this inquiry. Of interest to the inquiry is that the staff reading out the question indicated that the question would not be read out as it contravened the procedural bylaw and was derogatory towards council. The person who submitted the question could be heard saying, quote, "Unbelievable waste of time," end of quote. Mayor Fort then invited this individual to change the language of the question and submit it to council for consideration. She advised that person if he put the question in a nicer way, she would answer it. At 51 minutes and 46 seconds, Mayor Ford called C2 to present his questions orally. She introduced the question as, quote, "Pay grid and municipal act." C2 started his question by warning the OPP officers present that if they plan on purchasing a home in Hornepayne, they should be wary of the residential tax rate. He then asked council if anyone knew the tax rate. This question was taken by Mayor Ford, and she turned to Ms. Badavania for the answer. Ms. Badavania replied that she did not know the precise rate. However, it is over 4%. C2 then responded, it's 5.7%. C2 already knew the answer to the question he asked. C2 turned again to the OPP members and said that if you purchase a house in Hornepayne, they're going to pay $20,000 in taxes. Mayor Fort interjected. C2 shouted over Mayor Fort and continued. Mayor Fort raised her voice and called C2 by name and told him that he was supposed to be asking council questions. C2 cut Mayor Fort off and was being very loud to the point of shouting at her. Mayor Fort then addressed C2's question herself. C2 then argued with Mayor Fort and continued to speak over her, being very loud, and stated to her, quote, I suggest you guys tell the truth, end of quote. As Mayor Fort tried to interject, C2 shouted over, attempting to persist with his questions on the issue. Even while C2 was being disruptive and being very challenging in his first question to council, Mayor Fort had staff pause the timer for C2 while they attempted to address his points on the tax rate. Staff then provided C2 with the detailed information on the issue. At 54 minutes and 51 seconds, C2 was back on the clock. He moved on to pay grids, directly challenging the personal pay rate from Ms. Badavania. saying she was undereducated and so on for her pay rate. He then complained about the pay rates for the acting treasurer. Mayor Ford tried to interject and C2 spoke over in a loud voice. He continued in what was essentially a rant about the pay grids, and Mayor Ford again tried to interject. C2 continued to speak over Mayor Ford until she was able to ask him what his question on the issue was, as up to that point, there was no question by C2 on the subject for council to address. C2 then questioned why Ms. Badavania was paid at the rate she was. He also asked why they had to pay someone who was inexperienced in the position. Mayor Ford then indicated she would answer the question. C2 then loudly and argumentatively asked Mayor Ford, quote, "Why do you get to answer?" End quote. Mayor Ford responded that she chairs the meetings, she is the mayor of the town, and it's her duty. She advised C2 in no uncertain words that this was how the meetings would proceed, whether you like it or not. She told C2 to direct his questions to her, and she would direct him to the appropriate person to answer. This question was then answered by Ms. Badavania. She explained her experience and education for the position. C2 continued to challenge Ms. Badavania's pay rate. Mayor Ford then explained the hiring process for the CO and the position and the challenge they had. C2 continued to argue the issue. At 1 hour and 2 minutes, C2 began to yell loudly over Mayor Ford. Mayor Ford attempted to stop him, and C2 told Mayor Ford not to cut him off when he was speaking. Mayor Ford attempted again to regain control by telling C2 that she could cut him off and called C2 by name several times. He continued to yell over her, saying that he has Charter of Rights Section 2. C2 continued to argue with Mayor Ford and yell over her. At 1 hour and 2 minutes, Mayor Ford told C2 to stop talking. C2 persisted in the behavior. Mayor Ford then asked C2 to please sit down or she'd have to ask him to leave the meeting. C2 then stopped his behavior. At 1 hour and 35 minutes, C1 returned to ask questions about the deputy clerk, pay rates, education, and so on. C1 is asking why the municipality was paying for the deputy clerk's education instead of investing in restructuring. These questions were addressed by Mayor Ford and Ms. Badavania. C1 also asked if council had voted in closed session to eliminate these positions as part of the restructuring. This question was improper and not answered by staff. C1 then asked if the organization restructuring was really a restructuring or was it about someone individually. Her question and those of C2 were the same as several issues raised by C1 in her various complaints about Mayor Ford reported on here today. C1 was re-asking the same questions in a new venue about her own personal job loss at the municipality due to the restructuring. The discussion on this issue with C1 continued for several minutes. She continued to ask the same questions that were in her complaint about Mayor Ford. Staff, including Mayor Ford, indulged the questions, even though at a certain point, C1 became argumentative, and it was clear she was asking questions about her own personal employment and release from the municipality. Mayor Ford interjected that they would get C1 a full answer and post it to the website. At 2 hours and 2 minutes, C2 returned to the microphone for an additional question. In this case, he was addressing issues he framed under sections 253 of the Municipal Act. For reference, the section deals with public access to records under the control of the municipal clerk. C2 again went on about the municipal tax rate, complained about that Ms. Badavania did not know the proper tax rate and questioned how they could have her leaving the municipality based on false information. Quote, "Why did she not know this? It's basic accounting," end of quote. Mayor Ford attempted to speak and C2 spoke over her and continued to question why Ms. Badavania did not know the answer. Mayor Ford cut C2 off and told him that she runs the meeting and she will answer the question. As she was explaining that staff cannot know every last point being asked, C2 cut her off. He was loud and argumentative. He asked Mayor Ford and council what the commercial tax rate was. He challenged Mayor Ford and council, quote, "Okay, Cheryl, what's the commercial tax rate? You've been here for 8 years." Mayor Ford attempted again to interject in C2's conduct. He then turned to council at large and said, "You guys are running the show, preaching all this stuff, all the money, and all the glory days and sunshine of the world here. What is the industrial tax rate?" When he was saying this, he was at the best being facetious. and he was being mocking. Mayor Ford then offered to get the information for C2, saying she did not know it off the top of her head. C2 replied that there are 7 of them, one of them should know the answer. Mayor Ford told C2 that this is not a debate and that she would get him the answer. She also advised C2 that his conduct was edging on the code of conduct and that they did not know the answer, but they would get it for him. C2 then spoke over Mayor Ford and said, quote, I know the answer, I'll tell you, it's 7.7 industrial rate and the commercial rate. C2 continued to speak over the Mayor Ford while she said his motivation for the question was to make council look and staff look stupid, and she was not going to have it. She then told C2 to sit down and he was done speaking. C2 continued to argue and speak over Mayor Ford. Mayor Ford called for him by name several times in an attempt to get him to stop. C2 was very argumentative at this point and was shouting over Mayor Ford about his freedom of expression, charter of rights, and so on. At 2 hours and 4 minutes into the meeting, Mayor Ford said to C2, you are being asked to leave right now. You can leave. I'm asking you right now. I'm going to ask you once to leave the building. If you don't, you'll get escorted, end of quote. While Mayor Ford was telling C2 to leave the meeting and before her statement ended, an OPP officer can be seen walking off camera towards C2. Mayor Ford did not ask the officer to do this. A second officer also approached C2, presumably to assist in removing C2 from the meeting, and this was all done off camera. Interview with Mayor Ford. Mayor Ford was interviewed for her perspective on what occurred during the meeting. Mayor Ford provided inquiry that they hosted a town hall meeting on September 17th, 2025. They try to do these annually. It gives the community an opportunity to interact with staff and ask questions of council. These are submitted in advance, in writing or orally. They're a structured meeting to ensure that no one member monopolizes the meeting. They had decided to host the town hall back in July 2025 to introduce the new CEO and also the new OPP officers as they were being assigned to the community. There were several questions throughout the meeting. Many dealt with the restructuring and the process of doing this. There were a few community members who raised questions about the restructuring, including C1 and C2. C2 was asking about the municipal tax rate. He was being quite aggressive about it. He wanted to know why council and staff members did not tell him the tax rate off the top of their heads. She was trying to explain to him that she doesn't see it as a problem, not knowing the rate. Council focuses on the monetary increase per household. They want to know the actual impact and do not necessarily know the actual tax rate by percentage. Ms. Badavania was also new in her position. She was just hired about 3 months prior. Then C2 told the audience that he, in fact, already knew the answer to the question he was asking. Therefore, at that point, I believe C2 was just trying to make it look like council didn't know what they were doing. This is not true. They have a very engaged and active council. C2 was trying to control the meeting and direct who would answer questions. Mayor Ford indicated that as mayor, she's the spokesperson in the role and speaks on behalf of council. It was a difficult meeting. Mayor Ford advised that she asked C2 to stop talking and sit down, do not listen or respond to her appropriately. She believes he was infringing on the code of conduct by being disparaging in his treatment of people at the meeting. Eventually, she told him that if he was not going to sit down and listen, she would have to ask him to leave the meeting. C2 did not comply with Mayor Ford's direction, and she asked him to leave the meeting. The OPP officers in attendance got up and removed C2 from the meeting without her asking them to do this. Mayor Ford really just wanted C2 to sit down. C1 was there with him, and it was really uncomfortable as she had just been restructured. The police were not there as they expected issues. They were just there as they were invited to introduce themselves to the community. In the moment, Mayor Ford thought she was following the process. It was a town hall meeting, and she thought of it different from the regular council meeting. They have discussed amending the procedural bylaw to address town meetings. Mayor Ford submitted the inquiry, even though there is a process within the procedural bylaw to remove somebody from the meeting, it does not exclude her from her position from asking someone to leave the meeting. Mayor Ford explained the personal impact of the complaints and the conduct she has experienced from C1 and C2. She's dedicated to the community, is very thankful to have such a good council. Being a mayor and balancing a full-time career is difficult. Mayor Ford was emotional when explaining the impact of these matters, calling it traumatizing, and said it has impacted her health and her well-being in general. The meeting of September 17, 2025 was the first time she had to speak to C2 since he had harassed her in her workplace. This time it was in a public forum. She had prepared herself for this moment. She tried to keep her tone level and not to let C2 get under her skin. Then it was enough, and she had to do something about his behavior. Mayor Fort felt that she was the one who had to protect council and staff. She called C2 out for already knowing the answer to the question, quote, "You're just coming to make us look stupid. They don't deserve that," referencing staff. Mayor Fort stated that she did not go into the meeting to remove someone. C2 got a lot of chances, and she likely could have had to remove him earlier from the meeting. Text message from C1 to Mayor Fort, December 30th, 2025. C1 texted Mayor Fort on her own on December 30th, 2025. It was unexpected. C1 said she was putting out an olive branch. Mayor Fort thought this was manipulative on C1's part, explaining she had not done anything to C1 or C2 to require an olive branch. C1 then got upset in the text message because Mayor Fort did not respond. The message ended with the following quotation. "Hey, cool, if you're not afraid of me, or if it ever comes time my presence doesn't bring shivers down your spine, or make the hair in the back of your neck stand up, or make you sick to your stomach," and then there's some emojis printed with the message, "I'll be there as a friend." Mayor Fort does not know why C1 sent this text message. There were some protective measures in place for Mayor Fort after C1 was found to have breached the OHSA in regards to Mayor Fort while in the workplace at the municipality. However, she's not sure if this is what C1 statements are related to. All of this is expending energy of staff, council, and expending taxpayers' costs. Complaint February 27, 2026, restructuring. On February 27, 2026, C2 filed a complaint. The following is quoted from the complaint by C2. This complaint concerns the actions taken on or about July 29, 2025, respecting the restructuring and or the alteration of the statutory positions of treasurer for the Township of Hornepayne. It is my position that the restructuring or alterations of the statutory office may have occurred without compliance with required legislative governance processes. This allegation is all about the termination of C1's employment. In many ways, it is a refiling of the complaint made by C1 in her conflict of interest complaint. The inquiry also noted the complaint offers no evidence at all to substantiate the allegations. The opening statement of the complaint acknowledges the lack of evidence when C2 stated the alleged misconduct may have occurred. As will be explained later in the report, the inquiry has refused to investigate this complaint, as on its face there is no evidence offered to support the allegations. This matter has been addressed in other complaints, and C2 is clearly a frivolous and vexatious complainant. Review of meeting minutes, agendas, and declarations of pecuniary interest. The inquiry has reviewed 26 declarations of conflict of interest filed by Mayor Fort. They span from June 11, 2024 to November 2025. In reviewing these declarations, it is apparent that Mayor Fort repeatedly recused herself from personal matters involving her own employment and family-related matters. She also recused herself many times for legal matters and discussions about the harassment complaint filed against her by C1. The discussion about the restructuring of municipal staffing, which led to C1's termination, began after June 9, 2025, the date of Ms. Badavani's appointment as CAO. On June 25, 2025, the investigation of the harassment allegations against Mayor Fort were completed. Shortly after this investigation was completed, the restructuring began and C1's employment was terminated on July 30th, 2025. Throughout this timeline and after, Mayor Fort declared a conflict of interest. C1 alleged in her complaint that Mayor Fort did not attend the July 23, 2025 council meeting, and then failed to file her declaration of conflict of interest at the next meeting on August 13th, 2025 upon her return. This is true. However, Mayor Fort did file the declaration on September 10th, 2025. It was very apparent from the evidence that Mayor Fort was very diligent in ensuring that declarations of conflict of interest were made on the issues involving C1. She even made the final declaration after the conclusion of the harassment investigation when it was no longer required. Analysis on the conflict of interest. The MCIA sets out provincial law that governs the conduct of elected officials with respect to conflict of interest. The MCIA is clear that when elected officials have a pecuniary interest in a matter, they must recuse themselves from the discussion and declare their conflict in writing. They are also barred from attempting to influence the matter in which they have a pecuniary interest, even if they have declared the interest. A pecuniary interest deals with some type of impact, positive or negative, on the member's financial situation. It can also be that it impacts the value of their assets. The actual pecuniary interest cannot be some type of remote possibility. It must be real and crystallized at the time of the failure to declare the conflict of interest or when the unlawful influence of a process occurs. The municipality's procedural bylaw 2047 is consistent with the interpretation of pecuniary interest. Bylaw 2047 states a pecuniary interest means direct or indirect pecuniary interest, monetary interest, in relation to the Municipal Conflict of Interest Act. The Code of Conduct for members of council and local boards, bylaw 1749, also governs conduct of elected officials. It encompasses the principles of the MCIA and expands them considerably. The pecuniary interest alleged by C1 was described by her as Mayor Fort being able to avoid civil liability for her conduct during the course of the harassment investigation against her. She also alleged that by terminating her position for with the municipality, it would allow Mayor Fort to have unchecked ability to claim expenses against municipal funds. C1 also alleged that Mayor Fort influenced the restructuring plan that resulted in her termination from the municipality, thereby facilitating her, Mayor Fort's pecuniary interest and ultimate breach of the MCIA and Code of Conduct. Typically, the analysis of a conflict of interest under the MCIA or Code of Conduct is twofold. First, the inquiry looks at whether or not there's a pecuniary interest. If there is reasonably one that can be articulated, the inquiry then looks at whether or not the respondent properly managed this conflict of interest by declaring conflict where not required and refraining from influencing the decision-making process. With regards to the MCIA, C1 could not credibly articulate any meaningful pecuniary interest that Mayor Fort did or could have in the conduct she was alleging with regards to the MCIA. For example, it is nonsensical to assert that removing C1 from the workplace would in some way allow Mayor Fort the freedom to take advantage of municipal coffers. The notion is remote in the extreme. With regards to the Code of Conduct, it is reasonable to assert that Mayor Fort had a conflict of interest in matters involving C1 while the harassment complaint against her was investigated. This is due to the broad language in the Code of Conduct. It defines pecuniary interest more than just monetary interest. It includes bias, prejudgment, closed-mindedness, or undue influence. C1 failed to provide any evidence to support that Mayor Fort in some way influenced the restructuring that saw C1 terminated or that she involved herself in any way in matters relating to C1. All the evidence points to the opposite conduct by Mayor Fort. She recused herself repeatedly from meetings involving the issues, the restructuring did not occur until after the harassment investigation ended in Mayor Fort's favor. And most importantly, the restructuring was Ms. Baudivani's plan she brought to the municipality on her hiring on June 9, 2025. C1 asserted a confluence of steps taken by Mayor Fort going back many months to influence C1's dismissal. The reality is that the idea of the restructuring was not Mayor Fort's, and that the process began after June 19, 2025, weeks before the dismissal occurred. C1 is not a reliable or credible witness. She failed to provide any evidence in support of her allegations. At best, the assertions were made based on her own conjecture, rumor, and her own self-interest. Her complaint is clearly frivolous, and she is also a clearly vexatious complainant. The allegation that Mayor Fort breached the Municipal Conflict of Interest Act or Code of Conduct bylaw 2047 is unsubstantiated. To be clear, it is not that there is a lack of sufficient evidence to support the allegation made by C1. The reality is that there is no evidence at all. This is why the inquiry ended with the interview of C1 and Ms. Baudivani and the documentary review. Analysis of breach of procedural bylaw 2047 town hall meeting from September 17, 2025. Bylaw 2047 is a procedural bylaw for the municipality that governs meetings of council. Although C2 has made numerous allegations under the Criminal Code of Canada and the Charter of Rights of Freedom against Mayor Fort, it is the allegations under bylaw 2047 that give jurisdiction to this inquiry. The Trespass to Property Act is also relevant to this event. The allegation by C2 is that Mayor Fort breached bylaw 2047 and how she had him removed from the town hall meeting of September 17th, 2025. His evidence to the inquiry was that in his deposition before council, he was not arguing or being confrontational at all. He further explained that Mayor Fort stated to him that she was making them look stupid and to get out. He alleged that Mayor Fort told the police to throw him out, and they did. At the time C2 was asking them the municipal tax rate, he asserted that Mayor Fort never warned him before throwing him out of the meeting. And C2 was adamant that he was polite and that there was no reason for Mayor Fort to have him removed from the meeting. Part of C2's complaint is that Mayor Fort only put part of the bylaw 2047 on the screen, and she failed to display the mechanisms to remove someone for bad behavior. He complained that in doing this, Mayor Fort caused the police to take illegal actions against them, resulting in Mayor Fort committing a number of criminal offenses. In watching the video of the meeting, it is true that on the screen behind Mayor Fort only displayed details on the prohibited activity for the meeting, but not the consequences of that conduct. That this fact alone does not advance C2's complaint in any way. The recording of the meeting permitted an unbiased review of everyone's conduct at the meeting for September 17th, 2025. This has been described in detail in this report. It does not need to be repeated. The inquiry finds that C2 misled the inquiry on how he characterizes behavior of September 17th, 2025. He was loud, argumentative, abrasive, and very disruptive in his conduct. Mayor Fort was very patient with C2. Mayor Fort also had a duty to maintain decorum and decency at this meeting of council. It appears C2 was disrupting the meeting and purposely being antagonistic to council, Ms. Badavine, and Mayor Fort. It was very apparent that his intent was to embarrass and argue with Mayor Fort and council. The inquiry finds that C2's behavior was very serious, and the Mayor Fort had a duty to gain control of the meeting. By the time she asked C2 to leave the meeting, she had warned him at least twice, and at the end of the exchange, she told C2 he was very close to breaching bylaw 2047. The inquiry does disagree with Mayor Fort on one point. She should have ejected C2 from the meeting prior to this point, as his conduct had already breached the rules of decorum repeatedly. The inquiry finds that there was ample grounds to eject C2 from the meeting. The question is whether or not the proper process was followed in doing so. Bylaw 2047 requires Mayor Fort to essentially call out C2's behavior and ask for a vote of council to remove him from the meeting. This step was not done. It was in the heat of the moment that was created by C2 that Mayor Fort asked C2 to leave. C2 created the spectacle at the town hall meeting on September 17th, 2025 that Mayor Fort had to respond to. He's very abusive to her staff, and the rest of the council. It was while he was actively behaving in this manner that Mayor Fort ejected him from the meeting. The inquiry cannot find fault with how Mayor Fort acted. There is no reasonable expectation for her to accept this abuse for herself, staff, or council, and at the same time be expected to put the matter to a vote to stop the abuse. The Trespass to Property Act also provides Mayor Fort with very clear powers as an occupier of property to remove or to have someone removed from the property. In this context, there are no steps required, such as under bylaw 2074. Mayor Fort lawfully followed the Trespass to Property Act and asked C2 to leave the meeting. The inquiry also notes that Mayor Fort asked C2 to leave the meeting. It is arguable that before she could take further action, the police in attendance took it upon themselves to remove C2. They were not directed to do so by Mayor Fort. However, they do have their own powers under the Criminal Code of Canada and their general duties as police officers to keep the peace. Ostensibly, this is what the police did without a request from Mayor Fort. This negated the need for Mayor Fort to take any other steps under bylaw 2047, the Trespass to Property Act, to effect C2's removal from the meeting. The finding on the allegation that Mayor Fort breached bylaw 2047 by not following the process to remove C2 from the town hall meeting of September 17, 2025 is unsubstantiated. C2 was the architect of his own ejection from the meeting. Mayor Fort had the authority under the Trespass to Property Act to remove him, and police interjected before she had taken any steps under either the Trespass to Property Act or bylaw 2074. Conclusions and recommendations. Mayor Fort has been the victim of an ongoing campaign of harassment that has weaponized and the weaponization of the complaints processes against her. The inquiry finds that this conduct has been ongoing for several years and started in retaliation to C2's termination from his employment for harassing Mayor Fort. Because Mayor Fort became an elected official, this gave C1 and C2 other avenues to challenge Mayor Fort that do not apply to the general public. These processes exist for good reason. They are key components of our democracy and provide a mechanism to hold elected officials to account. Unfortunately, these processes can be abused by citizenry and can cause significant personal harm to the individuals targeted by malicious complaints. There's also a significant financial burden placed on municipalities for these investigations. It is clear to the inquiry that C1 and C2 have collaborated in the filing of these complaints. It is apparent that C1's MCI complaint had some complaint that someone wrote a portion of it for her, and there's the fact that C1 was directing C2, that C1 was directed by C2 to send materials to the inquiry while being interviewed for this matter. C2 could be heard responding to these directions by C1. There's also the fact that these complaints have a linear trajectory. They go from the finding of termination by C2 for harassing Mayor Ford at work to the filing of the various workplace harassment complaints by C1 against Mayor Ford in 2024, the filing of by C1 of her MCIA complaint after her job loss from the municipality in 2025, and the collective conduct by C1 and C2 at the September 17th, 2025 Town Hall meeting, and then finally the subsequent complaint filed by C2 on February 27th, 2026. The inquiry finds that there is a clear collusion between C1 and C2 in filing of these complaints. Under the Code of Conduct at 1749, there's definitions for vexatious and frivolous. Vexatious means instituted without sufficient grounds, served only to cause annoyance to the defendant, troublesome, annoying, vexatious situation. Frivolous means little or no weight or importance, not worthy of serious notice. There's also some clear guidance in the policy about the refusal to conduct an investigation. The inquiry followed the process as described. When it came to the final complaints by C1 and C2, the conflict of interest in the town hall meeting and the restructuring complaint, these investigations were halted when it became apparent the allegations were without merit. The inquiry further finds that the complaints made by C1 and C2 with respect to these matters are frivolous and vexatious. They have been reported to council as the inquiry finds there are exceptional circumstances to do so. These circumstances are intended to publicly explain the attacks by C1 and C2 on Mayor Fort and their impact on the municipality as a whole. The municipality owes a duty of care to its staff and elected officials. There's also a fiduciary responsibility in how they manage similar matters in the future. The following are recommendations by the inquiry to assist the municipality. The municipality should consider taking measures to protect staff and elected officials from a repeat of the conduct seen at the September 17th, 2025 Town Hall meeting. Following are some of these suggestions to consider. Should consider assigning a moderator to the meeting other than the mayor or another elected official. This will allow triaging of the questions to ensure they comply with the code of conduct. It would then be up to the moderator to manage the conduct of the participants instead of an elected official. Expand use of written questions. Potentially only allow a topic to be opened by written question, and all questions only be allowed in the following dialogue. Consider having participants sign into the meeting and ensure that the sign-in includes an acknowledgement of the code of conduct for participants. The municipality should also develop strategies to prevent elected officials from being personally targeted by complaints and the weaponization of the complaint process. The current code of conduct should be updated to include language on how to manage complainants who are deemed to be frivolous and vexatious. Once declared, consideration should be given to limit the ability of these individuals to file subsequent complaints in the municipality. This is similar to processes seen in the Ontario Court of Justice. The current multi-step process to remove a disruptive attendee from a meeting should be condensed. The mayor has the authority pursuant to sections 225B to preside at the Municipal Act to preside over council meetings so that its business can be carried out efficiently and effectively. This grants the mayor the ability to remove a person when necessary. While a warning before removal is best practice, depending on the severity of the behavior, it may not be appropriate. The safety of staff, council, and the public and public attendees is of the utmost importance. The constraints requiring voting on this issue, etc., may unduly delay safety. At the end of the report, there's a credibility assessment conducted of all the participants. Finding in regards to Ms. Badovania. I'm only reading just the finding portions. There's more verbiage in the appendix. Ms. Badavania, based on the balance of probabilities, the inquiry finds that Ms. Badavania is both a credible and reliable witness and is prepared to accept her evidence. Complainant number 1. The inquiry finds that C1 filed a frivolous and vexatious complaint against Mayor Fort with regards to the MCI Code of Conduct complaint from August 29, 2025. This is based on the definitions found in the Code of Conduct Bylaw 1749. The complaint was purposely made in bad faith and maliciously malign Mayor Fort. This is part of a long-term harassment of Mayor Fort done in concert with C2. C2. Due to C2's history of Mayor Fort, his untruthfulness with the inquiry, and his clear personal motivations for this matter, the inquiry finds that based on the balance of probabilities, C2 is not a credible or a reliable witness and is not prepared to accept his evidence unless it is corroborated by another source. The inquiry also finds that C2 filed a frivolous and vexatious complaint against Mayor Fort with regards to the Code of Conduct complaint arising from the Town Hall meeting on September 17, 2025, and against council as a whole in his February 27, 2026 complaint. This is based on the definitions found in the Code of Conduct the Code of Conduct Bylaw 1749. His complaints were purposely made in bad faith to initially malign Mayor Fort. This was part of a long-term harassment of Mayor Fort done in concert with C1. Respondent, Mayor Sheriff Fort. All Mayor Fort's key evidence was corroborated by another reliable source. None of her evidence was challenged in any way. Based on the balance of probabilities, Mayor Fort is both a credible and reliable witness, and the inquiry was prepared to accept her uncorroborated evidence. My apologies for the length, but that's the end of the report. And I'll take any questions that you might have. If you want to take a break, you can do that too. But I mean, I'm in your hands, Your Worship.
Yeah, maybe we'll just take a 5-minute, 10-minute break. We can have questions. It was a lengthy report. Give the council some time to look it over. And we'll meet back at, sorry, Jen, I can't see the time.
It's 7:06 currently.
So at 7:50. Sure, 7:50. We are adjourned. Our
15 minutes.
We are good.
Okay, we had our recess and we'll continue now if there's any questions from council about the report. And I open up the floor for council.
I do have
Yeah,
questions for you,
go
Mayor.
ahead, Counselor.
It's more of a curiosity, maybe you can correct me. One of the areas in there earlier at the meeting, the open house meeting at the Legion, he said the mayor should have considered, mayor chair, should have talked to council about before asking the person to leave. And they didn't,
That's
or
no
she
problem.
didn't.
Yeah.
But later on in the report, he said it's fine if they do. Or it's appropriate depending on the circumstance.
Right.
Can you clarify that, please?
Yeah, I can, like, again, your bylaw says that, essentially what the mayor has to do, if somebody's misbehaving, she gotta call them out for the behavior, and then eventually if she decides she wants them removed, she gotta go to council for a vote. It's not debatable, vote, you just vote yes or no and have them removed. I just don't think it's reasonable, to expect the mayor that while that level of abuse was going on, to actually put something to a vote to make it stop. And the other thing is too, is that within the context of what actually happened there, I'm asking you to leave,
Mhm.
not directing, and then also the OPP just kick them out. So it's debatable whether or not there's actually saying you gotta leave. And then there's also the Trespass to Property Act. As the occupier of property, like right now, I would say like your two senior people here is the mayor and you have your CAO, they're the senior people here. If they wanted to have somebody removed from the property, they could do it because they're the lawful occupiers of the property. So they should have other authorities to do it as well.
Right. Okay. Because the mayors are, represents all of council, right? So, I think it's logical that you can
Right.
speak to us.
Yeah,
for
and
us.
I really do believe that you should adjust your bylaw to allow for those decisions to be made. Again, if you're actively being, in that moment when somebody's really behaving like that and really hammering on somebody, like, you shouldn't have to put it to a vote to make it stop. But you should be able to say, that's enough, okay, and you gotta go. You should be able to just end it. That's what the recommendation's about. You shouldn't have to put up with it.
Thanks.
Counselor
I guess-
Keesmaker, go ahead.
When you say all that, do you, would one of us be able to just say, stand up and say, that's enough, can we just have this rectified?
Depends on what you put in your procedure bylaw and how you articulate it.
Okay,
So I would suggest you still want to have in procedural bylaw, but you want to maybe define what the behavior is, okay? And then what is the process? It could be just the mayor can make a decision, because I'm making a decision that you've breached the bylaw and you have to leave. So you could make it that simple so that it's that fast. You don't have to actually put up with something like that happened on me. Right? So you can adjust your bylaw, and again, you have a pretty good bylaw process with the CAO, and you also have a legal in the background. I'm sure you can come up with something that's very concise and very simple. You don't need a multi-step process.
okay.
Okay. Further questions?
I'm available to like reattend virtually if you want, or if you even just written questions, I'm happy to answer them. So.
Go ahead.
Yeah, Mayor, to you, to Sean. I usually like to have reports in my hand prior to, because I have a chance to read, study, and analyze. I did not have this one.
Yes.
I will, and CEO just gave me our copy. I will, if I have any questions, I will certainly directly to you
Yeah.
for answers.
And I apologize. It was my decision not to release in advance, and I'm hoping everybody understands just from the tenor of it why I did that. So. Okay.
Here.
Questions?
I'll stay for the rest of the meeting. That's okay with you, Mary?
Yeah, no, that's fine. I would just,
I'll just stop for a second.
yeah, I'm just gonna state, go ahead, Counselor
Just a
Keesmaker.
comment there. I'm hoping that this will somehow one more step towards the end of it. Maybe precedent set that we can maybe move on to more important things now.
Been a long time.
Yeah,
Yeah.
I think lots of resources.
It's exhausting, and it's really impacted people. I know it's impacted the mayor, so and other people as well.
Okay, thank you. Any motion to receive? Yes,
It's on the republished agenda, it's not on this one, sorry.
oh, sorry.
I can read it up for you.
Okay, we do need a motion to accept receipt of the report. If I can get a mover and a seconder, please. Moved by Counselor John Paroff, second by Counselor Belinda Kistemaker.
Be it resolved that council does hereby accept the Integrity Commissioner's consolidated report as presented.
Those in favor? And that is carried. Okay, moving on, we have new and other businesses, the fire department report, and I'll hand it over to Manuel.
Oh, sorry, everyone, I didn't, oh, sorry, did you wanna? I'm just going to pull up the fire chief as well. Oh, sorry,
No, that's all right. We can take a minute.
okay. Now, please, on the screen. Don't have it in front of me right now either. Sorry, I'm just opening it. So I prepared a report after our last meeting, just on the discussions we had regarding, the firefighter training. So Chief Wallingford at the last meeting, gave a lengthy report to council regarding all the issues with meeting the July 1st, 2026 deadline for the training and how we aren't going to be able to, as a municipality, meet that. So the recommendations of this report are that council receive the report for information regarding the township's inability to fully meet the July 1st, 2026 firefighter training certification requirements under Ontario's mandatory certification framework, and that council endorse a formal submission to the province of Ontario stating that the current firefighting certification implementation timeline and delivery model are not achievable for small northern volunteer fire departments under the current conditions, and that council requests a provincial extension of the July 1st, 2026 deadline for small northern volunteer fire departments and establishment of targeted provincial funding and delivery supports to enable compliance. So the remainder of the report is a summary of what Hornepayne has been experiencing and what our fire chief has been experiencing and trying to implement training, from trying to just have the people attend here with their jobs. A lot of times they're out on the trains, or to go even to a 3-day training course in Thunder Bay or Sault Ste. Marie. It's a day's travel there, 3 days, a day's travel back. That's 5 days that they're away. They're missing shifts. Or they just can't get the time off, or they don't have enough personal time to take it off, and they're not being able to meet these requirements. Some of the training is so extensive. He explained one test to me where they were asked how to fight fires in a skyscraper, which we're never going to have in Hornepayne. So it doesn't make sense that we're meeting downtown Toronto requirements in our training. Our training needs to be modeled around where we live and what our buildings are here and what our fire risks are here. So this is what this report addresses. It's asking that it be brought to other municipalities and to the province for consideration. And it's a report that we're asking that Mayor Ford can take with her to Good Roads, because she feels that she might have an opportunity to sit down with some ministries, and also to NEOMA and the mayor's group and NOMA and so forth. So we can definitely expand on it some more. There is a small resolution here at the end. The recommendation that council of the Township of Hornepayne endorse a formal request, to the province of Ontario for an extension phased implementation of firefighter certification compliance deadline currently set for July 1st, 2026, as it applies to small northern volunteer fire departments, and the establishment of dedicated provincial funding and delivery supports, including travel, accommodation, wage replacement or stipends, and mobile regional training delivery to enable rural and remote municipalities to meet certification requirements without reducing essential fire protection services, and that the mayor and the CAO be authorized to submit these requests and engage the ministry office of the Ontario Fire Marshal and relevant provincial partners. And it also recommends next steps being council's endorsement of the resolution and report, submit the report to the office of the Fire Marshal, the responsible ministries, the MPP Bill Rosenberg, and relevant municipal fire service associations. for alignment and application. Chief Wallingford to prepare a training status annex, which would include items such as the current roster, current credentials, estimated training gaps, hours, cost estimates for travel training to strengthen the submission to the province. So if we have some of this data from our chief to strengthen our submission, we're hoping it will help us in our endeavor. So if there's any questions, I will try my best, or perhaps Chief Wallingford is on the line, can answer some questions if there are any tonight.
Okay, thank you, Chief Miles Wallingford, for joining us virtually. We appreciate that. And also to the staff and for getting this information together. This, as you know, council, we asked for it last week and here it is. So I open up the floor for questions for the report. Go ahead, Councillor Peter.
Just more of a comment. You look at all the time that these volunteers are putting in, especially with Miles. They have lives of their own. They're not being paid for this. And the roadblocks that the government's putting up every day, there seems to be a new one. The set of tools that we don't have, the one resource that we don't have is the funding. And they come up with these, so just right off the bat, the training that these individuals have to take. A lot of the CN employees, you're looking at $4,000 to $6,000 loss in wages. And they're gonna have to use up their holidays to do it. And with no way to reimburse them. We're talking close to 7 figures for a pumper truck. It's just a perfect example of a cut and paste policies that are set forward by the provincial government that is good for the 905, 416, and the 519 area code and nothing else. It's absolutely ridiculous. There's times in life that these policies are handed down in new sets of rules and you kind of go, I don't like it, but it makes sense. There's nothing here. We're chasing away volunteers. I would put a volunteer fire department any day up against a paid one because they may not have the training, but they're there because they want to be and they want to serve their fellow community members. And we're just putting all these roadblocks in the way. And it's like we're trying to win a fight with our hands tied behind our back. It's really hard. But you know, my heart goes out to the people that are putting their time in and volunteers. And again, it's just, I cannot believe the rules that they're putting forward and there's no way that they can be met.
Mm-hmm. Well said, Councillor. I have to agree. And to expound on that is that our community isn't getting the protection it needs because we're trying to meet unrealistic demands and qualification standards. And we should be able to have qualifications where we can go into a burning building.
Yes.
How tall within Northern Ontario do we have to go for that burning building? Do communities that have, you know, in our case, no more than 4 stories, what does that mean for us? So I totally agree that we can't just have a one size fits all for Ontario.
Yeah.
So, yeah, well said. Any further comments on the report? Councillor Stanek.
Yeah, thank you, through the Mayor. Excellent report, Manuela and Mile, whatever people are involved, very solid. It's self-explanatory. All those issues for the last 40 years, basically, it was happening in Hornepayne. It's not the first year. My question through you to Manuela, submit reports to all those items you mentioned. That should go as soon as possible. I mean, time's of essence. Once it's approved, I think the mayor bring it up at our conference, be a dual effect, I think. I'm not sure about the date change, as I mentioned before. It looks like a solid one, but I think the other things that can be helped is financially. If we don't get financial help, there's no solutions. Thank you.
Yes, thank you for that, Councillor. And we will have the opportunity that I've been asked to sit on a panel with the chair of Roma, Krista Lowry, and the FCM vice president, Mr. Tierney. I can't remember his first name right now, I apologize. But Nigel Belchamber will be facilitating that panel on municipal governance. And so I definitely can, one of the questions I can answer to ensure that this becomes a topic of discussion. And we're not alone, right? Like, we see it across the minute, so thank you for that. And I also, John has graciously agreed to attend the Northeast Superiors Mayor's Group for me while I'm at the conference. So, and you'll present the information there as well, correct?
Yes, I will.
Right on, good. Okay, so is everyone in agreement with the recommendation? That's on the floor?
Yes.
Yes, yeah, thank you for that. Miles, do you have anything to add?
No.
No, it's all good? Okay. Okay, if there's any, is there any further discussion? I think we did have quite a lengthy discussion when Miles had presented at our last meeting, and we're moving forward, and hopefully we can get some movement on this concern. So if I can get a mover and a seconder for the motion, please. Moved by Councillor Peter Christomaker, second by Councillor Greg Spain. Be it resolved that council receives this report for information regarding the township's inability to fully meet the July 1st, 2026 fire training certification requirements under Ontario's mandatory certification framework. Be it further resolved that council endorses a formal submission to the province of Ontario stating that the current firefighter certification implementation timeline and delivery model are not achievable for small northern volunteer fire departments under current conditions. Be it finally resolved that council requests a provincial extension of the July 1st, 2026 deadline for small northern volunteer fire departments and establish a targeted provincial funding and delivery supports to enable compliance. Any further comment on the motion? There being none, I put it to a vote. Those in favor? And that is carried. And just one further, we're gonna send, we'll have the motion added to the report.
Well, yes, and I
By the
would like to
resolution?
send it to all small northern municipalities, so that they can also have it brought forward to their councils.
Okay, do you want me to reopen the motion and have a friendly amendment to it, or? it's
No,
fine? Okay,
Yeah.
that's fine. Okay, 7.2 is the amendment, the treasurer's statements of the 2025 council remuneration and expenses. And does the CFO want to speak to this?
I have nothing to add. It's based off of the financial information that was available in our system. And we haven't finished our 2025, but these are all, there's no changes.
Okay, okay, and this is by legislation, we should be posting it correctly now on our website and everything? Okay, so it'll go up for posting. Any comments on the report? Okay, there being none, we do have a motion for this as well. If I can get a mover and a seconder, please. Moved by Councillor John Farrell, second by Councillor Peter Kistmaker. Be it resolved that council receives the treasurer's statement of remuneration and expenses for the year ending December 31st, 2025 as information. Any further discussion? There being none, I put it to a vote. Those in favor? And that is carried. Okay, council, we have our adjournment confirmatory bylaw, moved by Councillor John Paroff, second by Councillor Belinda Kistemaker. Be it resolved that bylaw number 219626, being a bylaw to confirm the proceedings of council at their special meeting held on Thursday, March 26, 2026, be hereby read a first and second time, be considered read a third time, and finally passed. Those in favor? And that is carried. Adjournment of the meeting, moved by Councillor Drago Stefanik, second by Councillor John Paroff. Be it resolved that council does hereby adjourn this special meeting of council held on Thursday, March 2026 at 7:36 p.m. Those in favor? And that is carried.